Welcome to Law by Simpsons. This episode will be exceptions to the doctrine of privity of contract. In the last video, we went through a general introduction to privity of contract and how it could affect third parties' rights and liabilities under a contract which they may not be directly a part of, however, might be a third party to that transaction. Now we'll be going through a couple, not all, but a couple of the exceptions to privity of contract. The first exception to privity of contract is agency. Explained by Simpsons. We're going to use Homer, Mr. Burns, Homer, Apu, and Bart. Now, in this example, we're going to assume that Bart has come into a bit of money. We're also going to assume that Apu is selling chocolate bars. That's my drawing of a chocolate bar. And as Bart's father, Homer is going to act as an agent. So the actual exception is called agency. Now, what is going to happen in this scenario is Bart is going to give money and instructions to Homer. So acting as an agent for Bart, Homer will give the money to Apu with a condition of the contract that Apu is to give chocolate bars to Bart. Now, Apu is not directly contracting with Bart. So without agency as an exception to privity of contract, only Homer would acquire rights and liabilities under the contract. However, as Homer is acting as an agent for Bart, Bart also acquires rights and liabilities under the contract, and therefore, if Apu were to fail to fulfill his duties under the contract, Bart would have a cause of action to sue Apu for specific performance of the contract, or just in general. He would have a cause of action as he has accrued rights and liabilities under the contract. That's the first example. That's agency, as Homer was acting as an agent for Bart. Now, the second example we're going to go through is in insurance contracts. Now, in insurance contracts, for this example, we're going to use Mr. Burns, if I can find him, as an employer. Now, Mr. Burns, as the very caring person that he is going to take out an insurance policy with an insurance company. Now, this insurance company is expected to cover a class of people, or a class of workers. So this class of workers that we'll use Homer. Now, I don't have Lenny and Carl, but we'll use two other people who are workers or employees of Mr. Burns. Now, it's not just important that they're employees of Mr. Burns, it's important that they are a part of the class of workers covered, or that were supposed to be covered, by the insurance contract. Okay, so Mr. Burns has paid for the insurance policy, and that's important that he's paid for it. because the reason that this acts as an exception is because it could be argued that the insurance company is unjustly enriched if they deny a payment to the class of workers. Effectively, if one of the workers were to get injured, and it were to be covered by the insurance policy, the insurance company could argue that the contract is only between them and Mr. Burns, and that these workers are third parties to the contract. Therefore, they do not acquire rights and liabilities under it. Now, this was actually the case in the case of Trident General Insurance against McNeice Bros. Now, Blue Circle Southern Cement, who in this case will be Mr. Burns, took out a public liability cover from Trident Insurance, the insurance company here. And that was to cover Blue Circle, all of its subsidiaries, associated and related companies, all contractors and subcontractors and suppliers. That would be the class of workers. Now, at the outset, it should be made clearly known that the defendant McNeice were principal contractors of Blue Circle. So these workers were principal workers of Mr. Burns, who was taking out the insurance company. When the insurance policy when a claim was made, the insurance company argued that they did not have an obligation to pay out third parties due to the doctrine of privity of contract. However, it was found that the insurance company did owe the workers payment under the insurance policy, and that the workers did, even though they were third parties, did have a cause of action against the insurance company due to the exception to the doctrine of privity in insurance contracts. This is now covered by Section 48, subsection 1 of the Insurance Contracts Act.